SJC-10609, Commonwealth versus Agana.
Good morning, Ms. Murphy.
Your Honor. Good morning to all of you. Wendy Murphy here on behalf of the appellant. The first reported question asks about jurisdiction of this court in the first instance under 211.3. And, excuse me.
Let me ask you, assuming that we get to this standing, assuming all a million preconditions, did the judge here conflate the ability to communicate with competency? Is that causing some of the problem? He didn't really make a separate finding. You don't even get to ability to communicate unless she's competent. Because if she's not competent, period, it doesn't matter whether she has any ability to communicate. So aren't those really two separate questions, and you've got to decide competency first? Then if she's competent, you reach the question of whether with assistance she can communicate.
The definition of competency indeed includes both of those questions. It makes sense to me that they should be assessed separately in the way you suggest, because if a person isn't competent, you need to get to the next
communicate.
question.
That's what I'm saying.
But I don't think it's clear that a court is obligated to determine competency in the way you suggest. Nonetheless, it seems very clear.
But if a person isn't competent, what good is it why should you reach the question of communication through them?
Fair enough, although because competency includes the definition give expression to, I suppose a court could conclude that a person was incompetent because they can't give expression, and that isn't really about mental competency, it's about communicative competency under that phrase. Nonetheless, it's pretty clear that the judge below heavily depended on the inability to communicate in narrative style, citing that reason 3 different times in his ruling as really the primary, if not exclusive, reason for his ultimate decision around competency, although he did say that she understands the difference between...
Yeah, but that's what it seems to me causes the problem here, that this confusion. Just because she can't communicate doesn't mean she may not be competent, doesn't mean she may not be incompetent.
Agreed. Frankly, the hearing itself just didn't determine competency correctly. I think that's pretty clear.
Ms. Murphy, let me ask you this. This is a witness, and she's testifying because some party, not in this particular case, I know the party calls her as a witness. Much of what your belief goes to is a suggestion that it's somehow the responsibility of the judge to make the ADA determinations. In other words, you can proffer the witness, and if the opposing party says, look, this witness is not competent, then there's a hearing on competency. Or if the opposing witness says she is unable to communicate, then the party calling the witness has to demonstrate that the witness is able to communicate. Why does this all turn on anything other than the obligation of the party calling the witness to make the proper showing? And if party calling the witness gets an adverse ruling on any grounds, the party can then seek an interlocutory appeal, which may or may not be allowed. And if it's the Commonwealth, it'll often be allowed because of the natural consequences that flow if the witness does not testify. If it's the defendant, it usually is not permitted to make an interlocutory ruling. I mean, why wouldn't we just treat this as in any other case?
I have several reactions, and the first and foremost is that we're talking about individual rights that belong to a person, sort of separate from the role of the prosecutor as the possible proponent.
The person doesn't have a right. If, for example, I have been a witness to a crime, and I want to testify, and the Commonwealth doesn't want to call me as a witness, and the defendant doesn't want to call me as a witness, I don't have a right to testify. I'm only there because in our system, one of the parties is calling me.
Right. I think the answer to your question is, at what point do these rights apply? Certainly, they don't create a right to testify. The real question is, Once you've gained status as a participant, because that's the magic language from the ADA that gives the witness the rights to accommodation and against discrimination. So in a sense...
yeah, but the ADA is talking about a whole variety of situations. So if, for example, the defendant wants to call a witness, and there are cases to this effect, and the witness is physically unable to get access up the creaky stairs, and if the court says there can be no accommodation, the defendant has an appealable issue, not the witness.
Indeed. We're talking about a non-party, a third party, someone who really can't be aligned in the way you suggest with the prosecutor for a number of reasons, including that a prosecutor really shouldn't take on the responsibility of advocating for the individual, in this sense, constitutional rights of a person. It creates a possibility of so many potential conflicts of interest that I think that can't be the rule. Because a prosecutor may, for their own reasons, part company with how the disabled witness feels about whether the correct accommodation, if any, has been made. I mean, this case is a perfect example of that. There were no accommodations given. The prosecutor could have, but chose not to appeal. So this person's rights, very important constitutional rights, were
from my
without
point, redress. No, but at least, you know, I would say that at that point the Commonwealth was essentially saying, you know, I'm agreeing that I don't need this witness to prove beyond a reasonable doubt that this defendant has committed a crime.
Well, the prosecutor can certainly always make that choice to decline to use a witness for whatever reason. That's all their discretion.
I just don't see the conflict.
The conflict is that we have a case where an individual's fundamental rights were violated, but for having independent access to judicial review, they would remain
But you keep saying that. But let me suggest this. The prosecutor wants to call me as a witness. I was, in fact, the victim. And the prosecutor says, I'm going to call you as a witness. And I set aside, you know, whatever the date is, May the 6th. And then it turns out that the trial is rescheduled for May the 7th. And I say, I just can't make it on May the 7th. I'm unable to make it. And the prosecutor says, well, I'm afraid I'll have to go ahead without you.
But the point is that even if this case is remanded and there's a correct hearing and the witness is accommodated...
But whose obligation is it? You're saying we have some, as I read your brief, first you're here under 211(3), and second, you're asking us to instruct the judge to do something. Now, if the defendant, in my hypothetical, if the trial is rescheduled to May the 7th, and there had been no notice to the Commonwealth or the defendant, and the prosecutor says, Judge, I can't go forward on May the 7th because my witness is not available. That's one thing. If the prosecutor doesn't say anything or try to make the accommodation, why would, because it's an accommodation under the American with Disabilities Act, be different from the accommodation of any other kind of a witness?
Because I think you're putting the cart before the horse in the sense that once the decision has been made, and indeed there is a hearing at which a witness participates, that's the word from the ADA that matters most, that changes everything. Once you participate in the system, the rights kick in. And the reason it matters is this. It's not that you have a right to testify, which is what you're suggesting is the natural result of allowing third parties to seek enforcement and indeed to file appeals. It's more that once the decision has been made that you are a participant, and I think it's an interesting question who gets to make that decision, but in this case we clearly have a witness who did participate without accommodation, so your hypothetical is for another day, frankly, but it's a little bit like saying, because you are an employee who has a right not to be fired based on discrimination.
No, it's not at all like that.
You have a right to the job. You just have a right not to be discriminated.
No, it's quite different because the witness has no inherent right to testify.
I don't disagree with that. What I'm suggesting is that once the system has made someone a participant, and that can happen a variety of ways. A juror, for example, is a participant in the system.
A juror is very different.
Well, but this point is that that's when the participation kicks
No.
in.
The juror is very different. You have an absolute right to participate as a juror. Absolute right.
But the Tennessee versus Lane speaks to the different ways that people can participate. It's not always about being a party, and it certainly isn't always about the typical ways in which this issue has come up in the past, where the party litigant really has been responsible for enforcing or not the ADA principles. But the point is, if you are a witness, not that you have a right to be one, but if you are one, you have a right under the ADA to participate with accommodations and without discrimination, and we have that here.
How does one become a witness? When does participation kick in your view?
I've thought a lot about that question, and it seems to me, I mean, we can talk hypothetically, but clearly here, the prosecutor made the decision to have the appellant become a witness.
What you mean? So he put the person's name on a witness list?
Well, that's one thing that could define that moment.
Well, does it? Is it a defining event?
It could be. I'm loath to say it's the only thing that matters or the one moment in time that changes everything for purposes of, because I can imagine circumstances where, for example, a prosecutor systematically declines to use people with disabilities as witnesses in all criminal cases. So I don't want to give up the argument that there could be a different way to participate or to be discriminated against.
So a prosecutor puts up everybody's name on the witness list who may have seen something.
But this case
And that doesn't do it.
That doesn't. Being on a witness list could be an important moment, but here we had not only a person on a list that really doesn't exist, there's no physical list, but was a witness and did participate and was discriminated against and was not accommodated. So those hypothetical questions are important, but I think here we clearly have someone who was a participant.
We have the Commonwealth saying yes, and we think, and clearly because not only is she a witness in this case, but she's also the complainant. I mean, so she has these two roles, but I understand we're focusing on witness. But let's just say hypothetically, unlike this case, after this hearing, I mean, it's a sort of a variation of the Chief Justice's question. After the competency hearing and the judge makes the ruling that he makes, which is subject to, questions about whether that's valid or not, but the Commonwealth decides, we can go for, we don't have time to do this because of whatever reasons, and we can go forward in this case, even though we would have called her and would have liked to call her, we don't need her. And therefore, given the judge's ruling, we're just going to proceed in this case without her. So at that point, she's no longer a witness.
Granted, but she suffered legal harm that's redressable, and that's the important point, and it's the important reason why there has to be some mechanism for judicial review.
But you state it as a conclusion, and my question is the following. If, for whatever reason, a judge rules that a party's witness will not be able to testify, it seems to me that the redress is for that party to choose to take an appeal.
But the problem is,
in other words,
the problem is there's discrimination that happens that is entitled to redress irrespective of the discretionary decision-making of the government. And there's got to be a pathway, because it would violate due process to say to a person, your right of redress is owned by the government that did the harm.
She can bring a cause of action if she wants to against the district attorney or against the attorney general.
Here's another way to think about it. It seems to me very important that this court create an opportunity for independent judicial review, because if you don't, a witness like the appellant can go to federal court and can file a direct action, get all kinds of injunctive and other equitable relief. And in a way, I think providing a mechanism for review is a way of insulating that tension between the federal and state courts.
Where does that stop? We've always said that the district attorney has the discretion whether to prosecute or not, and where does that stop? The next witness will say, well, I have a small, what is a check collection case, and I want them to prosecute, and they didn't, and I have a right to appeal.
But our position is not that she has a right to testify. That's really not the issue.
So what is the relief that she's seeking in the federal court? She's seeking relief against the district attorney.
No, against the court system. The case in federal court would be appellant versus the court system, and her argument would be that she suffered damages because they failed to accommodate, and they in fact engaged in discrimination. She'd be entitled to money damages as well as some injunctive relief, which would not include a mandate that she be allowed to testify, because the prosecutor does enjoy total discretion in that regard.
Why isn't the remedy, I mean, as I recall from reading the briefs, doesn't every court have a ADA coordinator?
Yes.
So why isn't the remedy to complain to the ADA coordinator, who then presumably is operating under certain guidelines, administrative guidelines, that can take steps, and if they're inadequate, maybe there is a cause of action?
Very interesting question, because indeed the ADA contains specific language that mandates the public entity, including the court system, to provide prompt and equitable grievance procedures. And as far as I can tell, there's not a court system in this country that has any grievance procedure, much less a prompt and equitable one. On the other hand, I don't think that each court should be ordered financially to bear the burden of producing some kind of judicial review in the courthouse, and that's why
It's not really a judicial review. It's an administrative review.
But it's some kind of review of whether the right thing or the wrong thing happened.
So they should all come here?
Well, that's
I mean,
why
every witness who's found to be incompetent says, well, if I could be accommodated, I could maybe be competent. They're going to come here?
That's why I've suggested that you adopt, because I think it's really the perfect solution, the provisions that you've adopted under Silva, the 2007 case here, where you had to come up with something by way of redress for the media when they seek access to impounded documents.
The difference there is that in Silva, what the court did was graft onto the Uniform Rules of Impoundment Procedure. So there was an existing path to follow.
Granted, and I understand that, Your Honor. Nonetheless, there was no right of appeal, and you created one. You do have the power to create rules much like the uniform rules. You could do that here. And I think it's going to be a relatively infrequent event, especially when...
Why is it going to be a relatively infrequent event?
Because as soon as the rules are clear, and I hope that they are clear and clarified by this court, as soon as they're clear, the full opportunity to resolve disputes at the trial level, 9 times out of 10 is going to produce the right result and give people the accommodations they need. So I think it's likely to be a very rare case that actually makes it up here or to the single justice of the appeals court if the Silva rule
But
works.
how do we know that perhaps the DA didn't appeal because the DA thought the case wasn't worthy of prosecution for whatever reason, which is the DA's responsibility?
The DA has standing, but they have a limited piece of standing here. They certainly have an argument that they should be heard to deal on appeal with the integrity of their evidence. They have standing, but they don't have standing to address the personal and constitutional rights of the victim. So
But they do that all the time. When complainants come to the DA's office, the DA says, well, your complaint is valid, I'll prosecute, and yours is invalid, and I won't prosecute.
But it's a different relationship once the decision is made to use a witness in a proceeding. And I'm just saying, as this court said in Beale, the prosecutor does not represent the victim, and frankly shouldn't. Their interests can conflict, and there's an important
But perhaps
reason
once the prosecutor saw the victim testify, and I don't mean to be harsh or unfair, the prosecutor may have decided, I'm never going to make a case with this victim. I'm not going forward. And that is his prerogative.
And the prosecutor can continue to do that here. If this case is remanded and there's a fair hearing and she is accommodated, the prosecutor can still say, I'm not going forward, and I would have no recourse. And that's fair.
What reasonable accommodation do you say is appropriate here?
Well, the accommodations that the court's expert identified, I think, are a good beginning. But we should have a hearing on that.
The court's expert?
The court-appointed doctor who evaluated the
Right.
appellant.
I don't remember that person putting forward any reasonable
Dr.
accommodations.
Klein, indeed, recommended several accommodations,
Such
allowing
as?
yes and no questions, allowing her to take a long time to answer questions, allowing an assistant to kind of help her interpret and help people understand her answers. She didn't describe them as accommodations in magic language, which, by the way, is not required. But she did make suggestions, so that's a good start. But I think we have to have a hearing.
Can she write?
She cannot.
So, I mean, the problem here is
Not
that
really.
the accommodations that you're speaking of all go to the ability to communicate, which is a competency issue. So you're saying essentially that the judge was wrong in interpreting the obligation or the requirement to communicate effectively to say, no, that you should be able to say the reasonable accommodation here is that all parties must be limited to yes and no questions, that there must be somebody who knows the person who can interpret her motions and give words to them. That's what you say here is a reasonable accommodation.
Well, there were several options, and yes, in fact, the court is obligated, duty-bound under the ADA to offer those accommodations, and there are lots of cases cited in the amicus briefs in particular of courts around the country that have provided those kinds of accommodations.
Are you not questioning, aren't you questioning the judge's ruling? In other words, if the judge is saying competency, let's assume that the judge is using the term that you're saying Dr. Klein didn't use the magic words. The court didn't use the magic words. There was a hearing on reasonable accommodation. You're saying the expert put forward reasonable accommodations.
No.
The judge looked at the reasonable accommodations and decided that even with those accommodations, this witness
No,
was
I'm not
not.
saying there was a hearing, Your Honor. I'm saying that there were requests made, the family offered to provide assistance, and the one expert in the room who found a way to communicate using those things we can call accommodations, managed to communicate successfully. There was never a hearing on whether to have accommodations, what would they be, are they reasonable, and that is part of the problem. But I think everybody agrees in this case that there was absolutely no accommodation offered, and that's the essence of
Well, isn't it kind of implicit that the judge considered the suggestions that the expert made and said these won't work, that this person is not able to communicate, and thus I find her incompetent?
I think you'd have
Isn't that implicit?
No, indeed, I think you'd have to completely add that to the record. And indeed, the ADA, and there's no evidence of that, but the ADA, in fact, obligates judges to make specific findings, so I think we can infer that the exact opposite is true, that he never considered them at all. And it's not even a reference to the doctor's report in the judge's findings suggesting he gave no thought whatsoever.
Well, he did say they tried writing, and he said her writing is illegible, and thus we can't use that.
Which proves the point. He would have known that she couldn't write had he asked.
Ms. Murphy, I want to make sure I understand something you said earlier. I thought I understood you to say that you agree that the district attorney has discretion not to call this person as a witness. Could a district attorney, does a district attorney have unfettered discretion not to call members of a particular minority?
Well, I suggested that exactly was my point earlier. That I'm unwilling to make the most important moment be when a person is designated or placed on a witness list, because I'm worried about at least in theory, the possibility that a prosecutor could systematically decline to ever use disabled persons as witnesses, or all persons of a certain race and so forth.
Well, isn't that important as to who the focus is on? Was the focus on the district attorney or on the court system?
Well, in this case, it's the court system. In theory, it could be the prosecutor as an agent of the state. And, I don't envision that happening. I don't see that as a systematic problem. But if it did happen, then there should be a mechanism by which a witness, non-party, should be able to do something, either with this court in terms of seeking redress for that kind of discrimination, or, if necessary, going to federal court and filing a direct action against the prosecutor.
Thank you, Ms. Murphy.
Thank you.
Just hold on one sec, Susan. Thank you.
Sylvia, I'm sorry to just ask you this question.
Can we just wait until she introduces herself for the record?
May it please the Court. My name is Casey Sylvia, and I'm the Assistant District Attorney from Middlesex, appearing on behalf of the Commonwealth.
Okay.
And with me is Assistant District Attorney Marion Ryan.
I found it.
Your Honors, the Commonwealth's position in this case is that a disabled witness who is called to testify by a party, in this case the Commonwealth, and is denied reasonable accommodations under the Americans with Disabilities Act does have standing to invoke this Court's authority.
Why didn't the Commonwealth appeal?
Your Honor, in this case, the Commonwealth made the decision not to appeal because, at least through the prism of competency, which is how we were initially looking at this case, we believe that the judge acted within his discretion, that we were unlikely to be successful.
So what happens? We now send it back for a hearing, and there's an ADA hearing, and there's an attempt made at reasonable accommodation, and choose either alternative. The judge says, I'm ordering that this witness be reasonably accommodated in the following way, and the Commonwealth says, I don't want to have her as a witness. Or the judge says, I'm ordering that she not be reasonably accommodated. and the Commonwealth decides not to call her as a witness? What happens in either of those scenarios?
Your Honor, first of all, I think at the remand hearing, I would expect that the court, with the assistance of the Commonwealth, would make every attempt to make reasonable accommodations.
But what do you say are the reasonable accommodations? I mean, Ms. Murphy says the reasonable accommodations are matters which the court considered. The court recognized that she can't write, she can say yes or no, and she can gesture. And he said that really wasn't sufficient to respect the right of confrontation and the due process rights of the defendant. This person is not competent, therefore the person can't testify. I don't know what's going to happen on remand, because, I mean, it's not as if, it'd be one thing if you had Stephen Hawking's and it would just take a long time for him to answer questions, but he could, through the use of his special computer, answer questions and be able to provide narrative answers. It would just take a while. So there you may say, well, the reasonable accommodation may be do a deposition. It may take 24 hours and then compress it so that the jury doesn't have to wait while he types out or whatever he does to communicate. But you don't have that ability here. So I don't understand what the reasonable accommodation here is going to change anything.
Your Honor, it may well be that there are not reasonable accommodations that can be made, which, to get back to Chief Justice Marshall's question, in that case, if there are not reasonable accommodations,
No, but she says, if we accept your argument and the Attorney General's argument and Ms. Murphy's argument, that she has the right to appeal that. So she comes up here and says, that's what I'm saying, go either way with me. Go either way. So let's take the judge says no reasonable accommodations because it's not going to help with the deposition. And she says, wrong. There are reasonable accommodations. And I want to file a 211(3) petition with the Supreme Judicial Court because if we go that route, if she has standing and if she thinks her rights have been violated because the court said no reasonable accommodation, then she comes up here and has a hearing about whether her rights have been violated or not. And we say, either way, yes or no. It's very difficult for me to see how that is dealing with the reality of the litigants in the case, that in this case happened to be a criminal case, but there are also civil cases.
Your Honor, I do think that following a remand hearing, that were the petitioner dissatisfied with whatever accommodations the court does make or does not make, that she would have standing then again to bring a 211(3) petition.
And what if the defendant says, even if we said this is the reasonable accommodation that you have to make, and the Commonwealth decides to have that witness testify, does the defendant have any standing to say, I can't cross-examine this witness. I can't frame my answers with a yes or no. Many of us like to say, just answer yes or no, but often you don't want to just yes or no.
Well, Your Honor, I suppose that the defendant himself, as a party, could file a 211(3) petition, and if that were denied, all of his rights would be preserved for his direct appeal if he were convicted at trial.
But I think, and this is just an aspect of Justice Gantz's question, I think, you and Ms. Murphy are asking us in a way to shave the rights of the defendant to accommodate the rights of the Commonwealth and the complainant, because how can the defendant adequately cross-examine this person no matter what? I mean, if all she can say is yes and no and point, how can we preserve the right to confront?
We don't know that yet, do we?
Exactly, Your Honor. That's exactly what I was about to say, is that we don't know what types of accommodations can be made, and it may well be that they do conflict with...
Well, if you say a person whom she knows or a family member knows what she's saying, I mean, that is the most dangerous. That's like a witch trial. You can't have somebody who knows what she or he thinks the witness is saying,
yes, Your Honor,
interpreting for them.
I agree 100% with that, and that's we have that in our brief, that it should be a disinterested party. I don't know that there is any interpreter that can interpret for this witness, given the nature of her disability. But there may be other accommodations that could be made.
Well, do you know what other jurisdictions have done in this area? I mean, this must have come up in other courts. We can't be the first one to be faced with.
Your Honor, there are several cases that are cited by amicus by the Attorney General out of Arkansas, Illinois, and New York.
On speech cases?
Yes, Your Honor. Specifically, the New York case deals with an individual, a defendant, who had aphasia. And the accommodations that were made in that case were pretty similar to what the petitioner has
You don't see any
suggested.
difference between a defendant and a witness?
I'm sorry, Your Honor.
You don't see any difference between a defendant and a witness?
To be honest, Your Honor, I do see a difference between a defendant and a witness because the defendant has a right to a fair trial.
Yeah, I saw those cases, but has it come up in other jurisdictions with witnesses?
Witnesses.
Your Honor, I couldn't
Complaining witnesses.
I couldn't find any cases
Okay.
like that. I did extensive research on this. I couldn't find any analogous cases.
Might it not be because if the prosecutor or maybe the defendant decides that, this is not... When we use the term competency, we're not using the term, what does she understand? It is, as Justice Gans said, a communication issue, and we have communication. I mean, that's how we have an adversary process, and I don't know why the Commonwealth decided to offer her as a witness, or why the Commonwealth decided not to pursue the appeal, but it seems to me that that rests almost exclusively with the prosecutor.
Well, Your Honor, I think that the decision whether to call the witness rests exclusively with the prosecutor, and it may well be, for instance, in this case, we could choose not to call this witness after the remand hearing, and that would be within our discretion to do that. But I think that that's a separate issue than whether or not the court has accommodated this witness.
I'm looking at what we're being recommended to do here. We are being asked, for example, to have every judge ask every witness, do you need accommodation? That's one of the requests that's being asked.
And, Your Honor, I disagree with that.
Well, I mean, you may disagree with that. So then we have some accommodation, hearing, sight, right? And the prosecutor, it's not prosecutor, it's who's ever calling the witness. And then there's a claim, well, there wasn't an accommodation made because I couldn't really see the graphic. And up the witness comes on a 211-3. It's not that I'm insensitive to that. I'm trying to figure out how you do this in the context of a trial.
Well, Your Honor, I think what I suggested in my brief was that this should be brought to the attention, in the first instance, to the attention of the party proffering the testimony.
Well, say the party doesn't.
In that case, as I said in my brief, I do think that the petitioner should be able to bring a 211-3 petition to seek relief from this court.
Why?
Well, Your Honor, because first of all, there's a substantive right at issue, which is the petitioner's rights under the Americans with Disabilities Act, which is upon which all of this turns. That's the only thing that gives this witness a judicially cognizable interest in the outcome of these proceedings, in the outcome of this
But every
competency
witness
hearing.
found incompetent will have a mental impairment which will make that person disabled, correct?
I'm sorry, Your Honor, I couldn't hear the beginning.
Every person who was found incompetent will have a mental impairment which will make that person have a handicap or be viewed as disabled under the law, wouldn't they?
Your Honor, I suppose that is a possibility.
No, it's not a possibility. The ADA covers mental impairments, not just physical impairments. And I don't know, this may be physical and this may be mental. I'm not making that determination, but I'm talking about when we normally get to the competency in the sense of, I don't understand. This witness doesn't understand, doesn't have the capability of understanding. Does that give every witness a 211-3 right of petition, and we're going to decide whether or not they had an adequate ADA accommodation?
I think potentially, I think you might be right that would be the case. Having said that, what we propose is that this first has to be raised below before it can be brought up to the single justice. And I think that might cut down substantially on the number of
What
claims.
is the record that she raised a request for accommodation?
Your Honor, she did not raise a request for accommodation.
Well, then why isn't, if the prosecutor didn't raise it and if the witness didn't raise it, why are we even here?
Because she filed a 211-3 petition in the first instance with the single justice.
If we go your way, hasn't she just waived that?
Your Honor, it may be that she did waive it in this instance. However, the Commonwealth does request the opportunity to go back and to see what accommodations might be available to permit this victim to testify.
But couldn't you do that by asking the court to reconsider and saying that there are reasonable accommodations which we have just thought of, which were not considered, and with those reasonable accommodations, this person will be found competent?
And that's what we will do if this court does not remand it for a hearing.
And why is that not a perfectly reasonable remedy here, as opposed to opening the door to every person who was found, or every person more than 4 years old who was found to be incompetent, to be coming to the SJC, to be viewing the reasonable accommodation with regard to that finding.
Well, Your Honor, that's a different remedy from this hearing right here
No, but
today.
we only exercise, generally speaking, we only exercise 211(3) when there's absolutely no other possible way that this issue can ever be reached.
Your Honor, I think that that's a different remedy than remanding this case today, when there's no adequate or effective remedy for this witness because of the fact the Commonwealth did not take an appeal in this case, because of the fact that taking a separate civil action in a different court would not present an adequate or an effective remedy for her. In the time it takes to resolve that suit, the case in district court will probably be dismissed.
What's the current status of the case?
It's been stayed pending appeal.
So why couldn't you file a motion for reconsideration?
Your Honor, we actually did file a motion to stay these proceedings and remand to the district court so we could have a hearing on reasonable accommodations, and that motion was denied back in December by this court.
Are you stipulating that the Commonwealth did not decide not to go forward because it simply chose not to prosecute the case?
I'm sorry, Your Honor, are we stipulating
are you agreeing, are you representing that the Commonwealth did not simply choose not to go forward in the case because it did not want to prosecute the case for whatever reason?
Your Honor, we do want to go forward on this case.
Okay, that's what I'm asking.
We do want to have this victim testify if she is able to do so. And we do believe that there are options that would not violate the defendant's rights. And I also just want to point out that Your Honor brought up earlier the right to confrontation, the right to cross-examination. And I don't think that anything that the victim or the Commonwealth has suggested or amicus has suggested, I don't see that as violating the defendant's right to confrontation or to cross-examination.
Do you think that it would be fair to a defendant to impose the rule that there can be no narrative questions asked of a witness?
To impose a blanket rule or to impose,
Yeah,
in this case, to modify?
Yeah.
Your Honor, I don't think it would be unfair to a defendant for the court to modify its rules of evidence.
So all questions must be yes or no. That would be fair?
Why should this defendant be treated differently than any other defendant?
Well, it's not that this defendant is being treated differently.
Well, yes, he'd be limited to yes or no.
analogize it to child witnesses where special procedures are used, right?
Yes, Your Honor. Child witnesses or mentally disabled witnesses were special.
But they're not limited to yes and no answers.
Well, that may be one option, is yes or no answers. There may be other options, such as using tutorial aids.
Can I just get back to the procedural thing? What I'm hearing you saying is all of this could have been solved if the Commonwealth had asked the judge to have a hearing on whether or not reasonable accommodations could be made that were consistent with the defendant's due process rights.
And, Your Honor, had that issue been raised for us, had the
What do you mean raised for you?
Well, had the petitioner brought the need for accommodations, had she framed the issue, the legal issue, as an Americans with Disabilities Act claim, for us, we would have brought that to the attention of the judge, but she didn't do that below.
So she's waived it.
Your Honor, I do think in this case that the petitioner has waived that. However, having said that, we do ask that it be remanded for hearing in district court so we can try to accommodate this victim and so we can try to go forward on our case, which we do intend to prosecute.
It's an unusual case, Ms. Sylvia, because unlike some accommodations, which really are not obvious, I take it that that the tremendous difficulties under which she suffers as a result of her stroke are obvious.
Yes, Your Honor.
The Commonwealth is subject to the Americans with Disabilities Act.
As a public entity, Your Honor, yes. However, in this hearing, the court is the public entity.
No, I understand that. And so it's very hard not to conclude that the Commonwealth was content that she not be able to be a witness.
Your Honor, I can assure you that that's not the circumstance. We did choose not to take an appeal, but it was not because we're content not to have her as a witness.
Is it fair to say that you weren't quite clear what to do?
Your Honor,
I mean, it seems to me that you've got this sort of varying position over time. So that's how I interpreted it.
Your Honor, I don't think that that's an unfair thing to say. It's a complex issue, and it is something, as the Chief Justice pointed out, where the accommodations are not readily apparent. They're not immediately obvious. And it's an issue of first impression, and it's a difficult issue. I think it's unfortunate it wasn't raised below. I think it's unfortunate it wasn't discussed below because perhaps we wouldn't be here today had that happened. But I do agree with you that we're not entirely sure what to do with this witness, which is why we want a hearing in front of Judge Healy, because I think that he's in the best position as somebody who can see her, who can listen to her testimony and observe her. He's in the best position to determine what accommodations, if any, exist that would permit her to testify.
Could I just ask you a factual question, because I can't tell from this docket?
Yes, ma'am.
When was the actual hearing where she the competency hearing? Was that on September 11th? Was that the same day as his findings?
No, Your Honor. I believe that the hearing at which she testified was at the end of July, I believe.
Okay.
There were two different hearing dates.
So she testified at the end of July, and then the report from the psychologist is like September 10th, is that right? And then,
Your Honor,
and then his
dated,
findings are September 11th? Is
exactly.
That,
It is dated, the report is dated the day before the judge's findings.
okay, but it was after, clearly that's after the hearing.
Testimony, after
Right.
the hearing.
My understanding is that she testified on July 30th of 2009 at the competency hearing. But for
Okay.
whatever reason, the actual written report was not produced until September 10th, although the clinician had already testified.
Did she testify at the competency hearing?
The clinician?
Yes.
Yes, Your Honor.
Thank you, Ms. Sylvia.
Thank you, Your Honor.
Good morning, Mr. Clabberny.
Good morning, Your Honor. Richard Clabanner for the respondent, Kofi Agana. Justice Cowan raised a question concerning the definition of competency, and I think it's important to note that that has varying meanings in different contexts.
Of course.
And the question here was not whether she was competent to, the proposed witness was competent to handle her own affairs or was competent to be a defendant in the trial. It was simply limited to the question whether she was competent to be a witness. And that type of competency includes in its definition both the ability to recall circumstances and to relate them.
Would you agree, though, that there has been no hearing on whether or not reasonable accommodations can be made?
No, Your Honor. I think that there implicitly was such a hearing.
Well, what's an implicit hearing? We don't have implicit hearings. We have hearings or not.
We had a hearing, Your Honor, and
It was not on reasonable accommodations.
It was on, as the trial judge said, he made a determination as to how the witness could testify. And in doing so, he considered the accommodation suggested, though not in those words, by the examiner. The examiner suggested that the witness could testify if she was limited to giving yes and no answers, and the judge considered that as a possibility.
Leaving that aside, for because we'll have to look at that. I mean, obviously, Ms. Murphy disagrees with that. And leaving aside the waiver question, isn't the way this naturally should work, the way it worked in physical disabilities with Tennessee against Lane, and is that the witness or the party calling the witness has to say, I am competent provided that I have reasonable accommodations, and here are my proffered reasonable accommodations, suggested reasonable accommodations. The court has a hearing on reasonable accommodations, determines that those accommodations are not reasonable for an adverse trial, possibly because the jury can't understand, possibly because the defendant's rights are it has to do with accommodation. And if the witness or the party calling the witness doesn't make that request, the issue is waived.
Yes, Your Honor. There must be, as this court held an adoption of Gregory, which was subject to 16L letter I filed only yesterday,
Right.
so I'm afraid.
I saw that.
There must be a request below for the accommodation. It cannot be raised in this.
If we look at this record as we should, and we have done in other contexts, giving the importance of a complaining witness, giving the broadest possible interpretation to request for accommodation, are you saying there was no request for accommodation here?
That is the petitioner's position, Your Honor. In fact, in the petitioner's petition to the single justice, and again in the petitioner's brief, the petitioner says that the witness, though represented by counsel below, made no request for accommodation.
And am I correct that there is no record before us because the petitioner didn't provide us with a copy of the transcript of the hearing?
That's correct, Your Honor.
So we can't do what the Chief Justice said, which is go over the record to determine whether there was a request because we don't have the transcript.
The record is sorely lacking in this case, Your Honor.
But no one disagrees. There wasn't an express request for accommodation. Isn't that right? Either by the witness or the Commonwealth or anybody. No one. The initials ADA did not come up at this hearing. Isn't that fair to say?
The initials ADA did not come up. There was not only was there not an express request for reasonable accommodation using those words, there was no request for the concept of accommodation by the witness who was represented.
But there were suggestions made by the expert as to how she might be able to communicate, and then the judge decided those wouldn't work. Right?
Yes, Your Honor. That's correct.
So whether they used the words reasonable accommodation or not, there were suggestions we could try family members, we could try yes or no, we could try writing.
Yes, and the trial judge, in his discretion, found that those did not make her competent, would not be sufficient to make her competent as a witness. I might note that the trial judge found both an expressive problem and a problem with recall and with confusion, which is another standard, another part of
But
the
it wasn't
standard
clear,
competency.
right? But arguably one of them, in theory, might be subject to accommodation and the other might not.
That's correct, Your Honor.
Mr. Klebanov, I didn't have a chance to ask either Ms. Murphy or Ms. Sylvia, but the federal statute calls for every qualified individual with a disability shall, by reason of such disability, and there's a lot of case law about what a qualified individual is. In your judgment, what's a qualified individual in the context of this case?
Qualified individual under the federal law, to the extent, and the question about whether the ADA may apply in these circumstances or is binding on the competent circumstances, to the extent that the ADA applies, a qualified individual is one who can perform the task at issue with a reasonable accommodation. And I think one could well read the trial judge's decision as holding that given the accommodations, using other words, suggested she cannot perform those tasks, which are to accurately recall and to express what is recalled.
Okay, but even if the ADA were not to apply, do you agree that Chapter 93, Section 103 would, because it specifically refers to a person, regardless of handicap, shall be allowed to give evidence?
Right.
Yes, Your Honor. If that had been the basis for a petition, that could would be a consideration for this court. I agree.
So let's assume that it was. What would happen then?
Well, I think we're in the same situation.
I mean, do you think, though, if we're talking about, do you think that statute would give the witness an independent right because she wants to give evidence?
I think that statute does, well, first of all, I believe that statute, as the ADA, should be interpreted at least to require a request initially to set up that right. To the extent that there's a right under that statute, the remedy is providing the statute as a civil action.
But what good is that going to do? I mean, if we're talking about a pending case, the civil action may be wonderful prospectively, but it's not going to do a whole lot about the right of the witness at that point.
It will if there's injunctive relief, Your Honor. But you're right,
run
it's
into
not the
huge problems
easiest thing
there.
to do.
Right. I mean, there's a whole lot of law about enjoining particularly criminal cases.
I agree.
Well, doesn't Ms. Murphy make a perfectly straightforward case? As yes, there is a civil remedy, but why do we want to take the whole cotton caboodle over into the federal court when there should be a remedy here?
It doesn't have to be in federal court, Your Honor. It's concurrent
Of course.
jurisdiction.
No, I
of
understand.
state
I
courts.
understand.
And we still have the fundamental question of whether there is standing under Chapter 211.3 for a witness to come to this court.
I take it if there was such a civil action brought in either the Superior Court or the United States District Court, that the first question would be was a request for reasonable accommodation made? That is the fundamental starting point of every ADA complaint.
Yes, Your Honor, that would be the first question. And in this particular case, there was no such request. And I think that gets us to the question of whether whatever this court wants to provide prospectively as a set of rules, if it wishes to, for disabled witnesses, the question is whether it's appropriate in this case to rule on this 211.3 petition. We have a case where there was a hearing below, where the judge, well within his discretion, made findings, and that there's simply no evidence of an irremediable error, or any error, which is a requirement for Chapter 211.3. No further questions, I'll rest my brief.
Excuse me. Thank you, Mr. Cabana.